New on Curiosity Stream.
I'm James Burke. I'm going to take you on a journey through time.
James Burke's visionary series returns, reimagined for our time.
Now, this is all uncharted territory.
The Washington Post hails Burke as one of the most intriguing minds in the Western world. The New York Times raves he careens from one great moment in history to another.
Where do we want to go from here?
Experience all new Connections.
So what's the next connection?
With monthly, annual, and bundled plans, find the one that works for you at CuriosityStream.com. New on Curiosity Stream. How do you connect a 16th century potato to limitless energy production? Could Napoleon's toothpick have a direct link to a machine that predicts the future? And how can a 1700s conch shell chart a course to humans connecting their brains to the internet? James Burke's visionary series Connections returns for a new generation. Experience all new Connections. With monthly, annual, and bundled plans, find the one that works for you at CuriosityStream.com.
Welcome to Pretty Lies and Alibis. Let's seek the truth and travel the long road to justice together. What you know, Alibis, happy Friday. It's literally Friday, 12:51 a.m. I told you I was getting this done tonight because I don't know about my internet tomorrow. Let's just pray it don't go out because I'll be stuck in the house with 3 kids with no internet, and then I'll be busting out like Uno. So, yeah. Anyways, all right, so we're going to get started. And I'm going to tell you, I'm going to start with Chad's filings because Lori's is just, have you ever read, I know you all have, read something and then you have to read it like 3 times because you're just like spaced out. That's how that filing was for me. Chad's was a little bit more interesting, I guess you could say. Before we dive into it, song fact of the day, it's a new day. The song The Weight, which was featured in the movie Easy Rider by the band. I want to know how many of you guys sing Take a Load Off Annie, because if you do, you're wrong. It's Fanny. Fanny. Yes, it's Fanny. And when I sing it that way, people are like, it's not Fanny. And it is. I'm like, Google it. And then I win the Google war. All right. So also the song's meaning is about the impossibility of sainthood or the difficulty of living up to the world's demands. So there you go. All right, so we're going to talk about the very first and quickest filing of all, which is Chad wanting to wear street clothes to his pretrial hearings. This was dated September 27th, okay? Do we not know that there's no cameras allowed in the courtroom anymore? So who's gonna get prejudiced? Like the bailiff or something? Because like Chad has 2 tie options, essentially. I think I'm missing the blue one. But like the court reporter, the judge, and the bailiff, and the attorneys, like that's all that's going to see you, dude. They all know you're in the pokey. Anyways, all right. So the motion to sever had a few little nuggets in it that I thought was interesting. It gets repetitive. I'm not going to go through every single paragraph because for every argument that he has, he repeats himself just because he has to, and I'm not gonna. So he says that he plans to introduce prior bad acts of both Ms. Vallow and Alex Cox, as well as evidence regarding their relationship and the death of Mr. Cox. That sounds interesting to me, y'all. I just feel like that's kind of like a little tea leaf right there you could read, other than the fact that this whole motion to sever to me just indicates the honeymoon's over, Chad's over it, and yeah. So based on the allegations in this case, one of the plainly available defenses would be to demonstrate that Ms. Vallow and her brother Alex Cox were responsible for the crimes alleged and that they acted as part of their own conspiracy and did not involve Mr. Daybell. As part of that defense, Mr. Daybell would seek to introduce the prior bad acts of both Ms. Vallow and Mr. Cox, as well as evidence regarding their relationship and the death of Mr. Cox and the past statements of Mr. Cox. Interesting. Ms. Vallow's prior bad acts would bear upon motive, intent, and plan. In particular, Ms. Vallow's alleged involvement in the murder of her ex-husband, who Mr. Cox told police that he had shot, plainly bears upon the issue of whether Ms. Vallow and Mr. Cox had an ongoing conspiracy that preceded the core acts alleged in this case. Well, no, because we got all these texts by Chad saying, you know, when they found out that she wasn't the beneficiary, Chad was like, well, I wonder if he did it after he had 2 bullets in his chest. Come on. Well, look, I get it. Pryor's his defense attorney. He's got to do it. Okay. So as such, Lori Vallow's previous conduct easily merits the relevant standard for reverse, 404B. I didn't look that up, sorry. In fact, this information goes straight to the heart of Mr. Daybell's potential defenses, including any defenses that he did not commit the crimes alleged, that he was not engaged in a conspiracy, and that he had no knowledge of what occurred. This alternative perpetrator evidence is inconsistent with and raises a reasonable doubt of Mr. Daybell's own guilt, such that Mr. Daybell has the constitutional right to introduce the evidence regardless of state evidentiary rules, and he cites a case called Holmes. Moreover, because Mr. Cox is now deceased and cannot be called as a witness, obviously, I don't know, Chad could maybe go beyond the veil. Talk to him. I don't know. They got that gift, right? Mr. Daybell will likely need to introduce statements that Mr. Cox had previously made to the police, as well as others, pursuant to hearsay exceptions. So that's interesting. So Chad apparently didn't know nothing, but has got some dirt on Alex or things he said. I'm here for it, y'all. I'm here for it. He better allow audio in this trial. Y'all, I'm going to have to move my little booty to Boise in the cold. I don't do cold. So it says, however, while many of Mr. Cox's statements fall within a hearsay exception, any such statements that are testimonial would still violate Ms. Vallow's Sixth Amendment confrontation rights. And it says, even when not hearsay, it violates a defendant's confrontation rights under the Sixth Amendment, and explaining that whatever else the term testimonial covers, it applies at a minimum to police interrogations. But if Mr. Daybell cannot introduce evidence tending to exonerate him, it would constitute a denial of due process and an arbitrary limitation on his right to present a complete defense, particularly in light of the heightened reliability that is required at each stage of a capital murder case. I don't know if it says murder case because it cut off, but I'm just going to pretend it did. Yet another problem that is of lingering doubt in this case is likely to be a factor if there is a joint sentencing stage, particularly because the evidence is circumstantial and the state, despite charging the co-defendants with conspiracy, has little to no direct evidence that the two co-defendants have actually acted through agreement. Lingering doubt is a legitimate and important consideration in a penalty phase, but in doing so, point powerfully at another defendant as the major player. So a couple of times in here, he lets it be known that Chad is going to throw Lori under the bus like several times. And that's the only way you can do it. I mean, what are they going to do? If this is a joint trial, I mean, you have to. Somebody has to roll. It's a death penalty case. They're trying to save their life, even though we all know they didn't afford, these people up there, that right. By the way, Sherlock is right there. If I get randomly attacked, he is none too happy. I've made him stand aside because it's windy out, and it's going to be like a monsoon tomorrow. So it says Mr. Daybell will also be prejudiced in his ability to present a complete defense in a joint trial because he would be prevented from presenting exculpatory testimony from Ms. Vallow. In a joint trial, a co-defendant who has exculpatory information as to the other cannot testify without almost certainly providing information as to themselves or information that would be damaging to their case at the penalty phase. Under these circumstances, severance is the only way to hold a fair and reliable trial for both co-defendants. Now, don't forget, if you're new to this case, I know we've got a lot of new listeners since the Netflix series came out. And I always remind everybody, start at episode 1 of the mega series. It tells the whole story. He also says that a joint trial will turn the co-defendants into the other's most forceful adversary. He goes on to say Lori wanted a speedy trial and Chad needs time to prepare. I think it's interesting that originally Pryor requested that Chad go to trial in October of this year. So now he's saying, not only does he want a severance, he wants a continuance, We'll get to that. He also, the Bill of Particulars, essentially this means the Constitution guarantees the defendant has the right to know the charges and confront the witnesses and evidence against them. Pryor says, pursuant to State versus Neal, the defense recognizes that a Bill of Particulars is not a matter of right, but is within the court's discretion. So we asked this court to order the state of Idaho to produce the bill prayed for in this pleading as is supported by the Fifth and Sixth Amendments to the U.S. Constitution and is necessary to prepare a defense and to avoid a prejudicial surprise at trial. So the Bill of Particulars serves to furnish to the defendant further information respecting the charge stated in the indictment when necessary to the preparation of his defense and to avoid prejudicial surprise. It says that they cannot adequately prepare for trial without a Bill of Particulars as to the murder charges. Several features of this case stand out with respect to the allegations of murder in this case, which warrant the court exercising its discretion to order the Bill of Particulars. So then it says the discovery in this case obviously is huge, to say the least. Discovery is still ongoing, and as to this date, the date of this motion, the defense has a significant amount of discovery that has not been provided. Much of the discovery has been gathered over several years, and the defense is in the position of sorting through all the discovery which the prosecution has had in some instances for years. A Bill of Particulars would narrow down the possible alternative theories that Mr. Daybell would be required to defend against. And it also says Mr. Daybell has been incarcerated for over a year and a half under conditions that make it difficult to review technical materials and discovery. Well, that's what you get for being involved in all this. Taken together, these factors create a perfect storm of difficulties in preparing for trial. Without a Bill of Particulars identifying and defining the issues laid out below that the government actually intends to assert at trial, the defense will face the impossible task of preparing to defend against dozens of potential scenarios. So it says, under the current indictment, the government could change the theory under which it is alleging murder or conspiracy at its whim between now and trial, during the trial itself, posing a grave danger of unfair surprise. Finally, the prosecutors are pursuing the highest, most final, and harshest penalty allowed in our country. The defendant should have the right to defend himself and face accusers armed with the information needed to confront the government's allegations. So they go through the counts. It gets repetitive, but we'll go through the three victims clearly, as they are the focus of all this to me. Count one. Excuse me, the government's lawyers claim that there was an alleged conspiracy to take the life of Tylee Ryan and to commit grand theft of her monies by deception between and among Chad Daybell, Lori Daybell, Alex Cox, and other co-conspirators, both known and unknown, on or between the dates of October 26, 2018, and continuing until January 15th, 2020 in the county of Madison, state of Ohio, and elsewhere. Has that in quotes, including Fremont County, Idaho. It's necessary that the defense counsel be certain that the requirements of the statutes, court rules, and rules of evidence governing said conspiracy or conspiracies be satisfied, and that the government must identify with plain, concise, and definite written statements of the essential facts constituting the offense charged. That's Idaho Criminal Rule 7B. While the government is permitted to speculate as to the means of how the crime was committed, they are not permitted to speculate as to the specific actors or be so vague in their description of the event as to make the defense prepare for every scenario and every portion of the state of Idaho. The government has failed to identify indispensable parties, those being co-conspirators, as well as defining with they do the written statements of facts, dates, and events this alleged conspiracy occurred on or between. The language in the indictment describes some time between October 2018 and January 2020. The government has further failed to identify where, within the 1,369 square mile area of Madison and Fremont counties, this alleged conspiracy occurred, not to mention the elsewhere language, which is alleged to have occurred, the defense assumes, somewhere within the state of Idaho. So it says the defense requests the government be required to outline with particulars any facts that support the conspiracy with regard to the overt acts. The indictment states that the Chad Daybell, endorsed and espoused religious beliefs for the purpose of encouraging and or justifying the homicide of Tylee Ryan. The defense requests the written statement again. It says the defense has seen nothing in the discovery thus far which would support Chad Daybell's religious beliefs, either encouraging or justifying the homicide of Tylee Ryan. Has Pryor seen the light dark scale? Because that pretty much put her on the dark scale, which meant she was going to eventually become a zombie. Just saying. As to count 2 of the indictment, the government alleges that on or between the 8th and 9th of September in the county of Madison, state of Ohio, both Chad Daybell and Lori Daybell were concerned in the commission of first-degree murder and did aid and abet in its commission, or not being present, advised and encouraged its commission, or by command compelled another to commit the crime and did so with malice aforethought. So it says here, also the defense would like to know the identity of the unnamed person or persons as well as their addresses so the defense can investigate the allegation. So the known co-conspirators, I mean, we know Alex, but the thing with me is like nobody else has been arrested. So the only thing I can think is that either what they had against them probably wasn't much and they would much rather have their cooperation at trial, or I think this case, like a lot of it is going to be digital evidence and maybe it just wasn't there. Cause I know with like Melanice, a lot of you have said, well, why wouldn't she arrested for Brandon? Well, I think that's still under investigation, number one. I know they did say at that time they weren't charging her, but maybe the evidence just wasn't there. You know what I'm saying? I mean, like you can't just assume, you have to be able to prove it. I think that was the case with a lot of them. Like Melanie Gibb, I mean, she's got a lot of information. Zulema, I can't figure out how she got immunity. But, I'm not the prosecutor. It seems to the defense, this language is intended to disguise the language of a conspiracy into a separate charge. The government states in the indictment that both Chad Daybell and Lori Daybell were concerned in the commission of it repeats itself. Okay, so while willful, deliberate, and premeditated are all mentioned in the elements of the crime of first-degree murder, the word concerned is notably absent in the statute. The defense requests clarification on that. Count 2 of the indictment, the government's lawyers claim that there was an alleged conspiracy to take the life of Joshua Jackson Vallow, hereinafter referred to as J.J. Vallow, and to commit grand theft of his monies by deception between and among Chad Daybell, Lori, Alex, and other co-conspirators, both known and unknown, on or between the dates of October 26, 2018, and continuing till January 15, 2020. So again, it repeats that they want the written statement. While the government is permitted to speculate as to the means of how the crime was committed, they are not to speculate as to the specific actors or be so vague in their description of the event. So they say the same thing essentially for all of those. The government's withholding of evidence that is material to I need to put my glasses on, y'all. The determination of either guilt or punishment of a criminal defendant violates the defendant's constitutional rights to due process. The language in the indictment describes sometime between October 18th and January 2020. And then he repeats the mileage and, where within the state of Idaho. It also says that he endorsed or use his religious beliefs for the purpose of encouraging and or justifying the homicide of J.J. Vallow. Again, he requests the written statement outlining the specific facts the government is relying upon in this allegation. The defense has seen nothing in the discovery thus far that would support Chad Daybell's religious beliefs, either encouraging or justifying the homicide of J.J. Vallow. So count 4, the government alleges that on or between the 22nd and 23rd of September 2019, the county of Madison, state of Ohio, Chad and Lori were concerned in the commission of a first-degree murder and did aid and abet in its commission. He asked for the written statement. Count 5, they say the government claims that Chad, Lori, and Alex, sometime between October 1st, 2018 and January 15th, 2020, conspired to murder Tamara, hereinafter Tammy Daybell. The defense is requesting the government clarify this conspiracy as to the time of the conspiracy, as well as give a plain written statement outlining the specific facts the government is relying upon. So, Pryor should have the grand jury transcript. I know he requested it and he was granted that. So I'm curious if he's gotten that yet. But, he's a defense attorney. So it says, for the reasons stated above, defendant Chad Daybell requests this honorable court issue an order for bill of particulars consistent with the motion set forth above. So the motion to continue was a little more lengthy, and it was really but we're gonna pound it out, dudes, because here I am, and it's already 1:11. Oh, make a wish, it's 1:11, y'all. Let me find my spot because I haven't lost it. So it says he has submitted a motion to vacate the current trial date due to the substantial amount of trial investigation and preparation and significant amount of discovery not provided to defense still outstanding. I'm curious Rob Wood's response to this, not that we will see it. Any conviction and sentence resulting from a trial beginning in January will be unconstitutionally imposed and therefore vulnerable to reversal on direct or collateral review. In making this motion, Mr. Daybell relies on his right to be free from cruel and unusual punishment, his right to due process, his right to a fair trial, his right to counsel, present a defense, his right to confront witnesses, fair and reliable sentencing determination, and other rights safeguarded by the 5th, 6th, 8th, and 14th Amendments to the United States Constitution. There's no possible way to complete the investigation and be prepared for a death penalty trial by January 2023. I think part of it is just he doesn't want to go to trial with Lori, obviously, but then you kind of wonder, have they got some DNA stuff back that's, he got to figure out what to do with, or really is this just we don't want to hang with Lori for 10 weeks in a courtroom? Death penalty cases are unique in the criminal legal system and require counsel to undertake an extensive time-consuming investigation for 2 trials, essentially, the merits phase and the sentencing phase in the event there is a conviction. The merits phase is subject to heightened standards of reliability in capital cases, and the sentencing phase investigation is unique to death penalty cases and unparalleled in scope.
With no fees or minimums and no overdraft fees, banking with Capital One is the easiest decision in the history of decisions. Even easier than choosing to keep the Grinch away from the toy drive.
Who's going to deliver the toys to the kids?
What about me, the Grinch?
No.
Yep, even easier than that.
You steal the presents one time.
With no fees or minimums and no overdraft fees, is it even a decision? That's banking reimagined. What's in your wallet?
Terms apply. Capital One N.A. member FDIC. Copyright Dr. Seuss Enterprises. Copyright Turner Entertainment Company.
As more thoroughly discussed in this motion, due to the complexity of the merits case, which has dominated undersigned counsel's time, the sentencing phase investigation is in its initial stages. He also says there's substantial outstanding issues which must be litigated prior to trial. So he says that Mr. Daybell submits the motion now 4 months prior to the scheduled trial date in order to abate any possible prejudice to the state. The state previously asked this court for a trial date several months later than January 2023, and therefore a delay will only accommodate the state's prior request, but not after they've moved this whole trial to Ada County. I mean, I don't think he's going to get this, but pushing this case to trial prematurely will heighten the already very significant risk of reversal that is characteristic of death penalty cases. Indeed, studies demonstrate that reversible errors occur in more than 2/3 of cases resulting in the death penalty. Reversal often occurs years or even decades after the original conviction, given the unique and lengthy appellate and post-conviction process in death penalty cases, costing taxpayers millions of dollars. He wants a status hearing in January of 2023, which is, when we're having trial, and requests a trial date no earlier than October of 2023. I think Rob would ask for like September maybe of 2023, and Pryor wanted it literally like starting tomorrow or the 1st of October of this year. So something has flipped that switch in him. The state fundamentally changed the nature of this case when it filed a notice of intent to seek Mr. Daybell's execution. He mentions Chad's Sixth Amendment rights for effective assistance of counsel and says this puts significant obligations on the defense. Accordingly, the baseline investigation for the guilt and innocence phase must include the following. Number 1, charging documents. Copies of all charging documents in the case should be obtained and examined in the context of the law to identify A, the elements of the charged offenses, including the elements alleged to make the death penalty on the table. B, the defenses, ordinary and affirmative, that may be available to the substantive charge and to the applicability of the death penalty. C, any issues, constitutional or otherwise, such as statutes of limitation or double jeopardy that can be raised to attack the charging documents. And D, the defense counsel's right to obtain information in the possession of the state, the extent, validity of any obligation that might arise to provide reciprocal discovery. Then it says potential witnesses. Barring exceptional circumstances, counsel should seek out and interview potential witnesses, including but not limited to, number 1, eyewitnesses or other witnessings having knowledge of events surrounding the alleged offense itself. Number 2, potential alibi witnesses. Number 3, witnesses familiar with aspects of the client's life history that might affect the likelihood that the client committed the charged offense and degree of culpability for the offense, including members of the client's immediate family and extended family, neighbors, friends, acquaintances who knew the client or his family, former teachers, clergy, employees, coworkers, social service providers, and doctors, correctional, probation, or parole officers, members of the victim's family. Counsel should conduct interviews of potential witnesses in the presence of a third person, so there's someone to call as a defense witness at trial. Alternatively, counsel should have an investigator or mitigation specialist conduct the interview. Counsel should investigate all sources of possible impeachment of defense and prosecution witnesses. It says the police and the prosecution, counsel should make efforts to secure information in the possession of the prosecution or law enforcement authorities, which include police reports, autopsy reports. Take action today for a healthier tomorrow with Everlywell. Their at-home lab tests and vitamins and supplements can help you get the knowledge and support you need so you can become a healthier you. Everlywell is digital healthcare designed for you, all at an affordable cost and transparent price. With over 30 at-home lab tests, you'll be able to choose the test that makes the most sense for you to get the answers you need, like the women's health test or food sensitivity test. I took the women's health test and your girl's hormones were depleted. Got some hormones, feel much better. Would not have known without Everlywell. So here's how it works. Everlywell ships products straight to you with everything needed in one package. Take your at-home lab test, simply collect your sample and use the included prepaid shipping label to mail your test back to a certified lab. Your physician-reviewed results get sent to your phone or device in just days, and you can share the results with your primary care physician to help guide the next steps. If you order vitamins and supplements, you can start adding them to your daily routine right away. It's really simple. Over 1 million people have trusted Everlywell to support their health and wellness goals. And you should too. And for listeners of my show, Everlywell is offering a special discount of 20% off an at-home lab test at everlywell.com/whattheworld. That's everlywell.com/whattheworld for 20% off your next at-home lab test. everlywell.com/whattheworld. What the world are you waiting for? Get your home test. Cheaper than what you'll pay at the doctor, I bet you. Photos, video or audio tape recordings, and crime scene and crime lab reports together with the underlying data. Where necessary, counsel should pursue such efforts through formal and informal discovery. Then he mentions physical evidence. Counsel should make a prompt request to the relevant government agencies for any physical evidence or expert report relevant to the offense or sentencing, as well as the underlying materials. With the assistance of appropriate experts, counsel should then aggressively re-examine all of the government's forensic evidence and conduct appropriate analysis of all other available forensic evidence. The scene. Counsel should view the scene of the alleged offense as soon as possible. This should be done under circumstances as similar as possible to those existing at the time of the alleged incident, weather, time of day, and lighting conditions. A constitutionally adequate investigation for the sentencing phase of a capital case requires a comprehensive and exhaustive investigation into the client's entire life history in order to present a complete picture of the client's mitigating life circumstances to the jury. Because the sentencer in a capital case must consider in mitigation anything in the life of the defendant which might mitigate against the appropriateness of the death penalty for the penalty phase. Preparation requires extensive and generally unparalleled investigation into personal and family history. He wanted to interview everybody, like Chad's K-3 teacher, the nurse in the nursery when he was born. It's, I get it, but it's late for that. Why ain't you been doing that since June of 2020? The defense must conduct an ongoing, exhaustive, and independent investigation of every aspect of the client's character history record, any circumstance of the offense, or other factors which may provide a basis for a sentence less than death in order to meet their constitutional obligations. Compiling a comprehensive life history for a capital sentencing phase requires two primary responsibilities which are dependent upon each other. The responsibilities are collecting and analyzing records from the client and the client's family's life history, interviewing all individuals who have touched the client's life in more than a cursory manner or who may be able to shed light on circumstances shaping the client's life. Life history records that must be collected not only about the client but about the client's family members include, but are not limited to, all the following types of records. So not just Chad's, but family members. Medical history, complete prenatal, pediatric, and adult health information, exposure to harmful substances in utero and in the environment, substance abuse history, mental health history, history of maltreatment and neglect, trauma history, educational history, employment and training history, which obviously served him well when he was burying the kids on his property as a gravedigger. Military experience, multi-generational family history, genetic disorders and vulnerabilities, as well as multi-generational patterns of behavior, prior adult and juvenile correctional experience, religious, gender, sexual orientation, ethnic, racial, cultural, and community influences. He gonna be investigating until Jesus comes back, y'all. A socioeconomic, historical, and political factors. In addition to collecting and analyzing life history records, the defense team must be able to identify, locate, and interview life history witnesses in a competent manner that produces confidential, relevant, and reliable information. Lay witnesses will include people such as the client's family, extending at least 3 generations back, and those familiar with the client's friends, teachers, classmates, co-workers, employees. Siri literally just started talking to me, y'all. It scared me half to death. But I had a heart attack right here. Boom. as well as others who are familiar with the client's early and current development and functioning medical history, environmental, mental health, education. It just kind of repeats. For family, social service, and treatment providers to the client and the client's family members, including doctors, nurses, other medical staff, social workers, and housing or welfare officials. Witnesses familiar with the client's prior juvenile and criminal justice and correctional experiences, which doesn't apply to him, but former and current neighbors of the client and the client's family, community members, others familiar with the neighborhoods in which the client lived, including the type of housing, the economic status of the community, the availability of employment, and prevalence of violence. So you see now in a death penalty case, everything they pull from to try and convince the jury, spare this person's life. When I sat in on Jodi Arias, it was just one thing after another. I had a long conversation with her mom, actually, and she was a nice lady, I have to say. Felt bad for her having to go through this. She didn't choose what her daughter did, but people online ate her up. Witnesses who can testify about the adverse impact of the client's execution on the client's family and loved ones. As the mitigation investigation develops, red flags will become apparent. Any indications that a particular mitigating circumstance or theme may be present in the defendant's life history. When counsel discovers a red flag, it cannot be ignored, as to do so would be to abandon the investigation at an unreasonable juncture. The development of the mitigation investigation, including the identification of and subsequent follow-up on red flags, is dependent on the life history records and interviewing witnesses. The records component requires a thorough collection of all documentation about the client and his family. Such records are credible and may document events with the client and other family members were too young to remember, too impaired to understand and record in memory, too traumatized, ashamed, or biased to articulate, or events which the client knows nothing about, but which may document significant events or conditions in the client's life. It says most individuals who are the subject of a forensic evaluation are not able to remember their life histories completely, will remember events inaccurately, and will omit critical facts such as occurrences of head trauma. So we're going to go there. We're going to say the wave caused all this. Boom. He had a little boo-boo sticker on his back. I never saw a busted coconut on him, but the wave's coming in, y'all. So it says certain important areas of information such as prenatal history, whether their mother drank or took drugs during the pregnancy, early developmental issues, illnesses, exposure to environmental toxins, genetic predispositions to illnesses are not likely known by the defendant. Only through gathering of records, repeated interviews with people who had contact with the client throughout his life, and the analysis of all the information can a complete life history be developed. So it says it's vital the interviewer conduct these interviews in person, face-to-face, one-on-one, and that multiple interviews be conducted to establish trust and rapport in order to elicit sensitive information. Records from a client's visits to the emergency room might be evidence of physical maltreatment by a parent or caretaker and may establish relevant dates and identify potential witnesses. The authors of reports and documents are themselves potential mitigation witnesses unknown to the client and the family. Alternatively, a family member recalling that the client or his family received services from a community organization when the client was young may aid counsel in finding records that would have otherwise not been known to exist. Lord have mercy, y'all. At this rate, he's not going to be ready to go till Chad dies a natural death waiting on trial. There's so much. And death penalty is different. I understand the mitigation aspect of it. But man, I mean, this is some lady that treated you in the ER for a cut back in the 70s. It is insufficient to talk to witnesses only once because each new individual recalls different facts and anecdotes. If an aunt provides an account of a head injury, which the mother forgot to mention, it's necessary to go back to the mother and ask about it. It says an interview may reveal records that must be obtained, which in turn raise new questions which necessitate interviewing several witnesses again. See, this is the same thing they're doing for Lori right now, though. You got to consider. One thing that when I do Lori's, which I'm actually going to really condense, and I probably should condense this, is that he hints in there that they are going to use some kind of a mental health issue as a defense for her. It was not said directly, but it was obvious. It says, as the mitigation investigation nears completion, only then will it become clear to counsel what types of additional behavioral, cultural, or mental health experts may be necessary to develop the mitigation presentation in order to allow for individualized sentencing as required by the Constitution. Finally, counsel must complete the sentencing investigation prior to the start of the trial in any case where death is a possibility. It says that capital cases are frequently reversed for failure to conduct an adequate life history investigation. So it says, at this partial but lengthy list demonstrates prematurely having a capital trial under circumstances where the defense has not yet had sufficient time to adequately prepare the mitigation and mental health evidence is highly likely to result in a reversal of either the conviction, death sentence, or both. Since the indictment on capital murder charges is approximately 16 months ago, the counsel's time has been dominated by litigating numerous issues with the indictment process, discovery, the legal authority of prosecutors in this case, and a host of other matters, as well as reviewing discovery in a case that the prosecution has repeatedly referred to as particularly complex due to conspiracy charges. The fact that these two are co-defendants and other alleged co-conspirators, and that this investigation is occurring across jurisdictions for multiple alleged homicides, are alleged to have occurred months apart. Now, this is where it gets interesting. So, Lori, when Mark Means was kicked off, she got Archibald. Archibald hired his dude. She's got two very qualified attorneys. Undersigned counsel has been handling this extremely complex case alone until this point and is currently seeking qualified co-counsel in accordance with the ABA guidelines for capital defense, as well as the practical necessity of having more than one lawyer in a case this complex. At the current time, we have been unable to secure co-counsel. If and when co-counsel is hired, that attorney will require sufficient time to become well acquainted with the entire case to ensure decisions are informed and made strategically in accordance with professional norms for capital cases. Thus, co-counsel will require time to independently review all the discovery and get up to date on the defense investigation and all of the litigation completed to date. So it just talks about analyzing legal issues and strategies. It's going to take time when he brings on somebody new. A qualified attorney could not possibly complete the required work in the only 4 remaining months before a January 2023 trial date. It says investigation into the merits phase remains ongoing. The prosecution has recently made a request for additional DNA testing, and several discovery items have not been turned over to the defense. Though the prosecution has no less than 5 attorneys working on this case, 5 times the manpower of undersigned counsel, they have not yet complied with their discovery obligations. See, here's the thing, though. Pryor could have hired somebody a long time ago, at least after the indictment. Like, when you see the charges that serious, why are you not looking for co-counsel then? Time's time's flying. We're almost in October. We got 3 months, y'all. So now he's freaking out. It talks about how defense counsel is entitled to and required by ABA guidelines to independently examine with the assistance of qualified experts every piece of evidence the state intends to use at trial. And it says, thus, the state's delay hinders counsel's ability to complete the necessary investigation prior to the current trial date. It also requires interviewing everybody we mentioned. His constitutional rights must be assessed independently from that of his co-defendant. Then he puts a note, see the motion to sever, and his constitutional rights to effective assistance of counsel and a fair trial do not simply vanish if a co-defendant asserts a speedy trial right. So we're there, y'all. We're done almost. Holding that a continuance granted to a joint co-defendant needed to prepare for a complex trial. Oh, man. He talks about the speedy trial clock under federal speedy trial provision to be told for good cause. So essentially, he's saying he has good cause to continue this and not go in January. I don't think Boyce will go for it because, I mean, that train's left the station, y'all. I hear you can't get a hotel room in Boise the whole month of January. So you might see me on a sidewalk somewhere. Maybe I'll get a little RV and just park like right there at the courthouse. I'll just wake up and come out in a little trailer every day and go right to the courtroom. I done told my kids they're going to school in Boise. I really wouldn't do that, but hoping to be up there soon. So anyways, I wanted to get this in. I got it in. Sherlock behaved back there. Because he's been attacking me all night, y'all. Like, he is so mad at me. All right, so all of you guys in the path of this, like we are here, stay safe. For those of you who were affected yesterday, I am looking at ways to donate clothing, shoes, things here that I have that I don't need. I'm going to put up some things, some resources that have been put out there. So, if one or two of you guys are able to help these victims, that's better than none. So times like this, we got to band together and be a unit. So anyways, all right, guys, I am out. I'm going to bed. And we'll see you soon. I'll hopefully be covering Wagner tomorrow as long as I have internet. Plan to do an episode tomorrow if I have internet. So there you go. All right. Have a good night, y'all.
With no fees or minimums and no overdraft fees, banking with Capital One is the easiest decision in the history of decisions. Even easier than choosing to keep the Grinch away from the toy drive.
Who's going to deliver the toys to the kids?
What about me, the Grinch?
No.
Yep, even easier than that.
You steal the presents one time.
With no fees or minimums and no overdraft fees, is it even a decision? That's banking reimagined. What's in your wallet?
Terms apply. Capital One NA, member FDIC. Copyright Dr. Seuss Enterprises. Copyright Turner Entertainment Company.
With Lucky Land Slots, you can get lucky just about anywhere.
Dearly beloved, we are gathered here today to... Has anyone seen the bride and groom?
Sorry, we're here. We were getting lucky in the limo and we lost track of time.
No, Lucky Land Casino, with cash prizes that add up quicker than a guest registry.
In that case, I pronounce you lucky.
Play for free at LuckyLandSlots.com. Daily bonuses are waiting. No purchase necessary. Void where prohibited by law. 18+. Terms and conditions apply. See website for details.